As artificial intelligence continues to reshape the business landscape, C-level executives face an unprecedented challenge: navigating an increasingly complex web of AI regulations across different jurisdictions. This regulatory divide isn't just a compliance issue, it's becoming a critical strategic concern that demands immediate attention from leadership teams worldwide. The global regulatory landscape for AI is evolving rapidly, creating a complex patchwork of requirements that organizations must navigate. From the comprehensive approach of the European Union to the sector-specific regulations in the United States, executives must contend with varying standards, overlapping jurisdictions, and sometimes conflicting requirements. The stakes are high. Non-compliance can result in significant fines, reputational damage, and operational disruptions that can impact shareholder value and market position. The European Union's AI Act stands as the world's first comprehensive AI regulation, introducing a risk-based framework that will impact organizations worldwide. This landmark legislation categorizes AI systems based on their potential risk levels, from unacceptable risk applications that are outright banned to high-risk systems requiring strict oversight down to minimal risk applications. The Act's requirements encompass crucial areas such as transparency, risk management, data governance, and human oversight. Importantly, its extraterritorial reach means that any organization serving EU customers or using AI systems that impact EU citizens must comply, regardless of where they're based. Let's examine each risk category in detail, starting with unacceptable risk AI systems. These are systems deemed to pose a fundamental threat to EU values and human rights, and are explicitly prohibited under the Act. Examples include social scoring systems used by governments to evaluate citizen behavior, or AI systems that manipulate human behavior through subliminal techniques. Moving to high-risk AI systems, these are applications that could significantly impact people's lives, safety, or fundamental rights. This category includes AI systems used in critical infrastructure, education, employment, law enforcement, and healthcare. For instance, an AI system used for recruitment and candidate screening would fall under this category, requiring robust testing, documentation, and human oversight. Limited risk. AI systems are those that require specific transparency obligations. These systems interact with humans in ways that should be disclosed but don't pose severe risks. A practical example would be chatbots or deepfake detection systems, where users must be informed they are interacting with AI technology. Finally, minimal risk AI systems represent the majority of AI applications currently in use. These systems pose little to no risk to citizens' rights or safety. Examples include AI-powered spam filters or video games. While these systems fall under the Act's scope, they face minimal obligations beyond existing regulations. In contrast, the United States has taken a more fragmented approach to AI regulation. Rather than implementing a comprehensive federal framework, the U.S. landscape is characterized by a mix of state-level initiatives, sector-specific rules, and voluntary guidelines. The National Institute of Standards and Technology's AI Risk Management Framework provides voluntary guidance, while states like California are introducing their own AI-specific legislation. This creates particular challenges for organizations operating across multiple states, as they must reconcile varying and sometimes conflicting requirements. For C-level executives, this regulatory complexity demands a strategic response. The first step is establishing cross-functional compliance teams that bring together legal, technical, and business expertise. These teams should conduct regular risk assessments, monitor global policy developments, and develop adaptive governance frameworks that can evolve with the regulatory landscape. It's crucial to ensure that AI governance isn't treated as a mere compliance exercise, but is integrated into the organization's broader strategic planning. Board-level engagement is essential in this process. Executives must ensure their boards understand both the opportunities and risks associated with AI deployment and are prepared for various regulatory scenarios. This includes developing clear protocols for AI system documentation, testing, and monitoring, as well as establishing mechanisms for regular reporting to the board on AI-related risks and compliance matters. The path forward requires a delicate balance between innovation and compliance. Success in the AI era will belong to organizations that can build robust governance frameworks while maintaining the agility to adapt to evolving regulations. C-level executives must position their organizations to not just comply with current regulations, but to anticipate and prepare for future requirements. By treating AI governance as a strategic priority, leaders can create a foundation for responsible innovation that builds trust with stakeholders and creates sustainable competitive advantage in an AI-driven world.